3.6p, abnormal mental condition. Defendant has given ample testimony that he was in shock, state of disbelief, that he was under some sort of mental stress, if you will, as a result of the incidents, which led to his, I don't know, his 3.6p, abnormal mental condition. You're going to agree on it. So we have the email. Sorry, Judge,
go ahead.
there's also the issue of the self-defense instruction as to how it should be worded, so that we have an agreement on so we can get to an agreement for purposes of closing argument. That's what the law should be.
Did they give you a copy of what they want?
They did, Judge, and I reviewed it.
Would you like a copy, Judge?
I would.
Shoot, nice to write it in my copy.
Yes. All right, and what is it that you not agree on?
As well, do you want to talk about justifiable use of deadly force first, or do you want to talk about the abnormal mental condition?
The justifiable use of deadly force.
Judge, my objection is going to be just minor, in that the instruction allows for both the use of the word dwelling and residence.
Okay.
In the version that they provided, it only says dwelling. I don't know if it's.
I just thought that they would want dwelling instead of residence. Either way.
Yeah, it's not a major.
Residence is discerned. A dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent or mobile or immobile, which has a roof over it, including a tenant, and is designed to be occupied by people lodging therein at night. A residence means a dwelling in which persons reside either temporarily or permanently, or is visiting as an invited guest. I would say that it should be dwelling, not residence.
Okay.
Because I think that and the only reason I say that is we have an issue with the garage, so I want to make sure that it's clear that it includes the entire house.
Yes, Judge.
So we can, is that the only issue?
Judge, I'm going to go back and refer to my notes real quick to make sure. On the note that
You already have the definition that was given me, dwelling is, the definition is there.
Yes, Judge, I'm not. One more, Judge, please. Judge, that was the only note that I made, so.
Right, so it says dwelling in the one I have, so we're going to keep it as is, right?
Yes, Judge.
Okay. So that takes care of that. And issue is that you want 3.6P.
Yes, Judge.
Trying to even find 3.6.
We can't either,
We
it's
don't
not
have
our
it,
book.
Judge. It's not in the 2017 book.
It's in the Florida Supreme Court website,
That's where I'm going.
2017.
adopted in 2017. It's based on the case Chestnut v. State, which is located at 538 Southern 2nd, 820, 1989 Florida Supreme Court case.
Almost there. Got it? It's on the website. There's a Florida Supreme Court instruction right here on the website. 3.6P. Downloading it. And the instruction says, give if applicable and if requested, and only if insanity is not an issue, and if no notice of intent to rely on the defense of insanity has been filed. If insanity is an issue in the case, give instruction 3.6A. So it does meet the definition and you are requesting it. The instruction is mental illness or abnormal mental condition or diminished mental capacity is not a defense to any crime in this case. Any such evidence may not be taken into consideration to show that the defendant lacked the specific intent or did not have the state of mind essential to proving that he committed the crimes charged or any lesser included crimes. Okay? 17, so it's a fairly new instruction. Anything else, Dave?
Judge, we have, I think we're going to have 3 rebuttal witnesses,
Okay.
none of them very long. I think 2 of them are still in transit to get here, but we expect them within the next half an hour,
Okay.
half an hour to 40 minutes.
Judge, with regard to the jury instruction, it sounds like it would apply only to the count where the victim is Margaret, correct?
Well, I'm going to read it in general because it goes to his state of mind throughout the offense, and the jury can make out what it will. I'm not going to read one instruction and say, this instruction when we're talking about abnormal mental condition, somehow they're going to figure out how to put it in there. I mean, obviously, they can use it for whatever it's worth, just like they can use heat of passion instruction for whatever it's worth. They can use a self-defense instruction for what. I mean, I personally do not feel that self-defense would apply to Marker Brown, but I'm reading the self-defense instruction for all the counts. So I'm not saying, oh, here's a self-defense instruction, but this only applies to counts 1, 2, and 3, but it doesn't account for it. It's up to the jury. They could find self-defense applies to Marker Brown. I'm not limiting that instruction, nor will I limit this instruction. I'm reading self-defense, and they can use it for any of the counts. I'm not limiting that, and I won't be limiting this either, okay? So, State, I'm a little concerned about this 45 minutes, because I have the jury in the hallway, and I'm going to start, and then you're going to ask me to take a break.
We are ready with our first witness, Judge.
Okay. Well, we'll bring the jury in, and we'll deal with it when we get there. And hopefully, I'll keep my fingers crossed that these witnesses arrive while we're dealing with it, okay? In the meantime, everybody has the instructions, not the final ones, but close enough they think they can go into closing arguments with them. Yes? State?
We need the final self-defense instruction.
The one I have is the one we're going to use.
Okay, I don't have a copy of that yet.
We just have the draft from yesterday.
No, we have one copy printed out. I guess do you guys happen to have an extra copy?
You can have mine. I don't need it. I'll have the final when it's read. So here, this is the justifiable use of deadly force self-defense instruction. From what I can see, we use dwelling, it says dwelling, and we're all good with that. So other than that, we're good?
Yes, Judge.
Yes, Judge.
All right, bring the jury in. All right. They'll be admitted. Any other witnesses?
No, Your Honor, defense rests.
All right. State, any rebuttal?
Yes, Judge. The state would recall Dr. Noel Palma.
All right. Dr. Palma. Good afternoon, doctor.
Good afternoon.
If you want to step up, I'll remind you you're under oath, and you remain under oath. You can have a seat in the witness stand and speak in a loud and clear voice for me, okay?
Thank you.
State, you may proceed.
Thank you, Your Honor. Good afternoon, Dr. Palma. I'd like to focus your attention back to the autopsy that you performed on Nicholas Leonard. Okay?
Okay.
And you've described to this jury the process in which you go through to perform an autopsy includes both an external and an internal examination.
Yes.
As it relates to the external examination of Mr. Nicholas Leonard, did you find any evidence on the outside of his body that was consistent with a gunshot wound entrance?
Negative, no.
Did you find any evidence of a gunshot wound exit on his body?
No.
All right. In fact, all the bodies you looked at were in some state of decomposition, correct?
That is correct.
As it relates to Mr. Leonard's skin as compared to Mr. Gregory Brown's skin, what can you tell this jury about the state of composition between the two?
The skin were generally intact compared to the others.
When you have generally intact skin, as it relates to Mr. Nicholas Leonard, it would have been easier just to do an external examination looking for a gunshot wound.
Correct.
You didn't find any evidence of a gunshot wound on Mr. Leonard's body?
No.
Mr. Leonard had an injury to his chest area, and I'm going to reference the photograph. I'm referencing State's Exhibit 413. You know the injury of which I'm talking about?
Correct, yes.
All right. Is this injury consistent with a gunshot wound?
No.
And why not?
It is a very superficial injury, and when I did the autopsy on this case, there were maggots inside this hole.
Okay. And did you follow the path of this injury to see if it led anywhere?
Yes.
And did this injury go anywhere to his body consistent with a gunshot wound?
No.
You had an opportunity, and we kind of spent a fair amount of time talking about how you put back together Mr. Nicholas Leonard's skull pieces, correct?
Correct.
In examining the skull of Mr. Nicholas Leonard, did you find any evidence of beveling in the skull that was consistent with a gunshot wound?
No.
There were some injuries to Mr. Leonard's arm. I'm going to reference State's talking about State's Exhibit 415, the injuries to the arm, correct?
Correct.
All right. How would you describe the injuries to his arm?
There were superficial injuries, and those injuries did not cause trauma to the underlying major blood vessels.
All right. If you were to be, these injuries were to happen to Mr. Leonard, would there be such significant blood loss in the moments or minutes after it occurred that he would lose consciousness?
No, it will take a long time.
All right. Mr. Leonard also had an injury to his jaw, correct? And I'm going to reference
Correct.
State's Exhibit 411.
Yes.
You had an opportunity to examine the injury related and the damage to the neck, cheek area of Mr. Leonard, correct?
Correct, yes.
Was there any damage to any major arteries in that injury?
No, there are superficial injuries.
Okay. Same question, Dr. Palma. Would there have been such significant blood loss from this injury in stage 411 that in the minutes or moments after he would have lost consciousness?
No.
As part of your internal examination, did you have an opportunity to look at the heart of Mr. Leonard?
Yes.
Was there any damage to his heart?
No.
Do you have a chance to look at his lungs?
Yes.
Was there any damage to his lungs?
No.
Were there any injuries sustained to the abdominal region of Mr. Leonard?
No.
And there are a bunch of organs in there. The spleen, did you have a chance to look at that?
Yes.
How about his kidneys?
Yes.
What else am I missing in that area?
Liver.
I'm sorry?
The liver?
The liver, yes, thank you, sir. Any injuries to his liver in your examination?
No.
Are there any injuries to his body outside of the injuries to his head that would have caused him to lose consciousness?
No.
And Mr. Nicholas Leonard sustained, I think you said 21 injuries to the head?
21 blows. At least 21 blows.
Head is a pretty vascular region.
Excuse me?
There's a lot of blood vessels in the head, correct?
Correct, yes.
Those injuries would have been accompanied with a fair amount of blood and brain matter out, correct?
Correct?
Did you find any bag over the head of Mr. Leonard?
No.
As it relates to the autopsy that you performed on Miss Margaret Brown.
Yes.
Miss Margaret Brown sustained how many injuries to her head?
9.
9. And these injuries, there was one that was, in your words, would have been a fatal injury, correct? The injury to the side of her head?
There are multiple blows.
Multiple blows?
Yes.
One in particular by itself could have led to her death, correct?
Yes, the gaping one.
All right. And you, as the medical examiner, actually went to the scene where the bodies were located on Old Dixie Highway.
Yes.
You had an opportunity to observe how the bodies were stacked and piled in the wilderness area, correct?
Yes, yes.
And I'm correct in saying that there were a number of bodies that had ropes tied around them, correct?
Correct.
Miss Margaret Brown, was she the only person that had her hands zip tied?
Yes.
All right. The limbs, the arms, and the legs, as to the other bodies you examined, okay? We're talking about Megan Brown, Nicholas Leonard, and Gregory Brown.
Correct.
Their arms were still attached to their body, correct?
Yes.
Okay.
Yes.
But their arms were not bound.
No.
The height and weight of Miss Margaret Brown, you guys took both measurements of each, correct?
Yes, correct.
Can you tell this jury what the height of Miss Margaret Brown was?
5'2".
All right, and at the time that you performed the autopsy of Miss Margaret Brown, what was her weight?
75 pounds.
That's
Postmortem.
post-mortem.
And
there's
decomposing.
There's some weight loss due to decomposition, correct?
Correct, yes.
How does that compare to the height and weight of Miss Megan Brown?
Megan was 58 inches, 87 pounds.
Okay. You have a moment, Your Honor?
May I?
Dr. Palma, at the scene on Old Dixie Highway, we talked about there being a rope around some of the bodies, correct?
Correct.
Do you recall whether or not there was a rope or any type of cord or anything like that around the body of Megan Brown?
No.
There was not.
None.
Your Honor, I have no further questions.
All right, Ross?
Yes, Your Honor, just a couple. Good afternoon, Dr. Palmer. Nice seeing you again.
Same here,
You did testify, I think it was last week, or maybe it was the week before, but...
2 weeks ago, I guess.
Okay. I'm going to draw the court's attention to the transcript from Dr. Palmer's testimony.
Objection, improper impeachment at this stage?
Sustained. Do you have a question for the witness? Ask the question.
Yes, yes.
Okay? You haven't asked a question, so there's no reason to look at a transcript.
Okay, are you saying, sir, that with regard to Nicholas Leonard's injuries to his arm, he couldn't bleed out and fall unconscious within minutes? Is that what you're testifying here today?
All right, so basically what we have are superficial injuries, and the arteries in the upper extremities were intact. So if there's bleeding, it will be a slow bleeding. It will take a while for a person to be unconscious, to have a significant blood loss. Yes, it's fatal by itself, but it will take a long time for that person to be unconscious.
Okay, well then, again, I'm sorry to repeat, but I'm referencing the transcript from last week, page 96, lines
Can you all approach?
3 to 8.
Bring the transcript.
Of course. I thought it was filed.
Not that I know. Doctor, he's going to be asking you about the transcript. This is from 2 weeks ago, starting on lines 3 to 8. If you want to read that, and then he's going to ask you a question. Okay? Give the doctor a moment to read that, and then you can ask the question.
Sure.
I'm not sure it's phrased exactly the way you phrased it, so you can follow up.
Yes?
You had a chance to read it, doctor?
Yes.
Okay, so...
Nothing changed.
Say it again?
Nothing changed.
So, with regard to isolating the injuries to Nicholas Leonard's arm, you would agree with me then that with those injuries alone, he could fall unconscious within minutes if the hemorrhaging isn't controlled, right?
Correct, but if we're talking about the totality of the case, this is not the cause of death. The cause of death is...
I understand.
Okay.
I'm not doubting that at all. I'm just saying that injury alone could cause loss of consciousness within minutes, right?
It takes a long time because the major blood vessels are intact. So...
Well, what you just read to refresh your memory says within minutes it's possible.
Correct, yes. It's longer compared to when you have a brachial arteries cut. This is only
Obviously.
small blood vessels.
Right. And with regard to Nicholas's injuries to the head, it's possible that he could have suffered a gunshot wound, right, to the head, and it would be unnoticed by you because of the decomposition?
I did not see any evidence of a gunshot wound to the head. The X-ray is negative, so most likely the answer is no.
But it's possible.
I guess everything's possible, but
Not
very,
everything's
very
possible.
unlikely.
Do you think everything's possible?
You mean, what's your
Well,
question?
maybe I can refresh your
Okay.
recollection.
Because I don't think he said he didn't remember.
Okay. All right, I have no further questions.
Okay. Any redirect?
Just briefly, Judge. Dr. Palma, in reference to this bleeding on the arm, you make reference to the word, if the bleeding wasn't controlled. What do you mean by that?
Meaning the blood vessels were not clamped.
Okay. So if the person wasn't taking attention to it, correct?
Correct, yes.
The blood loss wouldn't have been so immediate that he would have immediately passed out, correct?
Correct. It takes a while. It takes longer compared to when the major arteries are cut.
Right. So if a major artery had been cut, you would have thought the unconscious nature could have happened much more quickly.
Correct, yes.
All right. But that's not what you see in this case, correct?
Negative, no.
All right. And as to the injuries of the head, based on your examination, you did not see any evidence of beveling on the skull pieces of Mr. Leonard, correct?
Correct.
As compared to what you saw on Mr. Gregory Brown and the injuries that he sustained.
Correct, yes.
No further questions.
All right. Doctor, you may step down. I'll take that transcript back. Sorry about that. Thank you.
Thank you.
And you're released to go back to Clearwater or wherever it is.
Thank you.
It takes a while to get there, wherever it is. All right, State, can you call your next witness, or do we need to take a break?
We have one more present judge.
All right,
We
call your witness.
State would recall Kimberly Ward.
Kimberly Ward. Good afternoon, Ms. Ward. You remain under oath. You're sworn, and I'll just have you take the witness stand and speak in a loud and clear voice, okay? Certainly. State, you may proceed.
Thank you, Judge. Good afternoon, Ms. Ward. We've already heard from you once, and we talked a little bit about the Fisherman Shack.
That's correct.
And you indicated that you regularly attend there.
Mm-hmm.
Are
Yes.
there a number of people who are regularly seen at the Fisherman Shack?
Absolutely. Yeah, we do have kind of a little community from doing activities like during holidays. There's a lot of this boat together, that type of thing.
Now, amongst that community, does Nicholas Leonard, or did Nicholas Leonard have any kind of reputation for peacefulness?
Yes, he was very nice, kind.
Objection, Judge. Let's not exceed the scope.
Okay, approach. All right, State, you may proceed. The objection is overruled.
Thank you, Judge. And Ms. Ward, I want to back up just a little bit. How many different people do you see on a regular basis at the Fisherman Shack?
Oh, I don't know, maybe 30, I would say,
Okay.
on different times.
And,
You know.
and these are this is a group of people that they know each other, and that there's a conversation amongst you guys about
Yeah,
each
camaraderie,
other.
yes.
Okay. And when Nicholas Leonard was alive, was he a part of that community?
Yes.
And again, in regards to any reputation Mr. Leonard had for peacefulness, how would you describe his reputation for peacefulness?
I would say that he would be more likely to break up a fight versus escalating a fight. Kind.
Beyond the reputation, Judge, that's specific. Just discuss it.
Did he have a reputation for peacefulness?
Yes.
I don't have any more questions, Judge.
Okay, Cross.
I have nothing, Your Honor.
Ms. Ward, thank you very much. You may step down,
Am I released?
hopefully. I thought you were last time, so. Is she released?
Yes, Judge.
All right, thank you, ma'am.
Thank you.
Judge, may we approach?
Sure. Ladies and gentlemen of the jury, this is the time I'm gonna have you step into the jury room. We're almost there. Don't talk about the case. No tweeting, texting, or blogging. I've kept your phone, so you really can't, but no talking about the case. We're almost there, okay?
Here is that of the presence of the court, Your Honor.
All right. All right, while we await the last witness, why don't we go over the jury instructions one more time, make sure that we're all on the same page so that closing arguments can begin as soon as the state rests. The instruction, introduction to final instruction and statement of the charge. Any objection to that?
Is this yesterday's draft, Judge, or?
It's the same, yes, it's only draft, yes.
Yes.
No
So
objection.
I don't believe we made any changes to any of it yesterday, other than adding the self-defense instruction. The question is, where do you want it?
The usual.
The front page is fine, I guess.
I'm sorry?
In the beginning is fine.
I would ask that we place it before when there are lesser included offenses.
That's what, we usually put it, read the charges, counts 1 through 4, and then we put it there, and then we put when there's a lesser included crimes or attempts, and then we read those. Any problem putting it there?
No, Your Honor.
State, any problem putting it there?
No, Judge.
Okay, so it'll be, we have these page numbered, so it'll be between page 13 and page 14. I also had my clerk work on a verdict form, which I believe she has done. If you want to approach and review those. Count 1 is pretty straightforward, guilty or lesser, second manslaughter, not guilty.
Judge, looking at this point, we don't want all the category 2 lessers other than the felony murder one.
What?
All the category 2 lessers.
Hold on,
Because
stop. Are you telling me that in our jury, our instruction pamphlet yesterday, I asked specifically, Murder in the first degree, murder in the second degree, manslaughter, yes. Anything else? No.
That was the first day prior to the defendant agreeing to testify. Once he testified, we think now that he's entitled to the other lesser included instructions.
So the instructions that we just talked about being great are not the instructions that you wish to read. So I can't go into final arguments unless we agree on what the instructions are. So I guess we're going to have a whole new instruction. We went over them yesterday. So hold on to that, and I'll give these back to you. So the defense is now asking for an entire different instruction packet than they asked for that we spent an hour and a half over yesterday. Is that correct?
That's correct, Judge.
Okay.
What specifically are they asking?
I don't know. I don't know what they're asking for. I gotta get over to murder and figure out what second lessers are asking for. When I ask to the defense what they want, and they tell me what they want, I usually rely on that, but I guess not. So, let me see. The category 2 lessers, category 1 lessers are second degree murder, deprived mind murder, and manslaughter. Those we talked about yesterday. The category 2 lessers include second degree felony murder, that's out. Attempted felony murder, that's out. Well, I don't know, I guess you could have an attempt, although they're dead. Are you asking for
We're not
that?
asking for that, Judge, no.
Okay, attempted premeditated murder, are you asking for that?
Yes.
Judge.
How do we have an attempt?
You can't. You have 3 dead bodies and admitting, 4 dead bodies, excuse me, and admitting the criminal act that led to the death of all 4 people. So I don't see an attempt. In fact, one person who probably was an attempt, he went back and finished it on Mr. Nicholas Leonard. So I don't really think that there was an attempt.
Let me pass that for a moment. I'll have to do some research. All right. So if you want an attempted premeditated murder, you also want an attempted second degree murder.
Yes.
And you want attempted felony murder?
No.
Third degree felony murder?
No.
Vehicular homicide?
No.
Attempted felony murder?
No.
Aggravated battery?
Yes.
Attempted manslaughter by act?
Yes.
And by the way, who are you asking? Are you asking your client, or are you asking lawyers that are not on this case?
Asking lawyers that are on this case.
Okay.
They're
Can you make sure you're asking your client?
Yes, Judge.
Okay. Felony battery, you want that?
Yes.
Ag assault?
Yes.
Battery?
Yes.
Culpable negligence?
Yes.
Which one?
One.
$784.051.
I'm looking under the instructions under 8.9.
Correct. 784.05 sub 1. That's the statute number.
Yes.
Assault?
Yes. And my client says that's fine with him, Judge.
All right.
Judge, I know, although the court's not asking for the state's position at this point, I just want to put out, we're doing the research to try to see if these are even permissible based on the facts that we have put out here. I'm sure that's what the court's doing as well. In addition to that, Judge, they've been more than helpful in preparing these instructions. They provided me the justifiable use of deadly force instructions so that we could include in the packet. At this point, I don't have anything from them for any of the instructions that they have now requested, so I'm just going to ask that Since they're requesting these, I'm asking that they prepare them so that we can include them in the packet, so that when we go to argue, we at least have an understanding what the law is going to be.
Judge, I'm going to withdraw a couple of negligence requests. Judge, can we approach very quickly?
Sure. Mr. Matos, it's my understanding that you and your defense team have decided that you would wish to just go with the category of one lesser included offenses, which means that I would read as charged, murder in the first degree, and then I would read that you could be found, if they don't find you guilty of that, you could be found guilty of murder in the second degree or manslaughter, or of course the end would be not guilty. So my understanding is that after further reflection on all of those counts, that you all have decided that you only wish to have the category one, we call them category one lessers, the ones I just read to you. You understand that?
Yes, Your Honor.
All right, do you need any more time to talk to them about reading anything other than those three?
No, Your Honor.
All right, you're okay with that
Yes,
and
sir.
that strategy? Okay. The court did not make a finding one way or other that I would or wouldn't read it. I was researching the matter. So at this time, since the defense has withdrawn the request for any other category 2 lesser, then the instructions that we went over yesterday were already prepared, and the only other additional instruction that we're going to put in is the justifiable use of deadly force instruction that the defense prepared, and we can put it in between page 13 and 14. And we're going to also add that 3.6p instruction. Where do you want to put that?
I was just going to have to put it right after their instruction.
Okay, that's fine. We'll put them both right there, and we'll move along. Did your witness arrive?
I believe so, Judge. We just go ahead and grab them.
Okay. We'll toss that tomorrow.
Judge, he's in the building and we're walking him up.
Okay, and, well, why don't we take this time, if anyone needs to use the restroom, use it now. That way we can put the witness on and go right into closing, okay? So the jury's in the jury room right now, so we'll take 5 minutes. 5 minutes, please, and make sure the defendant gets the chance to use the restroom, okay?
There is no present seated, Your Honor.
All right, State, call your next witness.
They will call Ryan McCann.
All right, Ryan McCann. Good afternoon, Mr. McCann.
Afternoon.
You remain under oath, and you can have a seat in the witness stand and speak in a loud and clear voice for me, okay?
Yes, ma'am.
Thank you, sir. State, you may proceed.
Thank you, Judge. Good afternoon, Mr. McCann. I only have a couple questions for you. Now, you recall testifying regarding the defendant asking out of the blue whether or not you had a security camera on Sunday, August 31st.
Yes, sir.
Now, it has been suggested that that may have come naturally from a conversation you were having. Were you having a conversation about cameras hidden within your residence that you used to produce porn videos?
No, sir.
Did that ever come up? Were you and Alan talking about that?
No, sir.
You didn't have any hidden cameras in your house,
No, sir.
and you weren't talking about that with your brother and this defendant.
No, sir.
And that was that how the surveillance comment came up?
No, it was not. No.
No more questions, Judge.
All right, Mr. McCann, you may step down. Thank you, sir.
Yes, ma'am.
We will rest, Judge.
All right, can I have the lawyers at the bench? All right, ladies and gentlemen, both the state and defense have now rested their cases. The attorneys now will present their final arguments. Please remember, again, that what the attorneys say is not the evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding this case. Each side has equal time, but the state is entitled to divide their time between an opening argument and a rebuttal argument after the defense has spoken. I will tell you that this packet of information is the jury instructions, which myself and the lawyers have spent time together while you weren't here working on. We all know what it says. We all agree to what I'm going to read to you. So it's not anything that they don't know, nor is it anything they don't already have a copy of. You all will get a copy of it when I read it to you. So if they reference the judge will tell you this or the judge will tell you that about an instruction, they would not mislead you. They know what I'm going to read to you, so listen carefully, okay? State, you may proceed.